No, that is not true. You can file with your spouse as long as you're legally married, but you're not required to do so. Now, the reasoning it may be a little bit arcane and requires us to take a step back into non-bankruptcy law. So when a couple gets married, all of their possessions get divided into three categories: the husband's separate property, the wife's separate property, and the community property. What goes into these categories? Anything a spouse comes into the marriage with, and anything a spouse inherits is that spouse's separate property. Everything else is community property, including, by the way, wages, because you don't come into the marriage with the wages and you don't inherit them. On the day you get married, there is no community property. Why is that? Because everything you have, you're coming into the marriage with. But as the years roll by, stuff breaks, you toss it, you buy a new one. Oh, how'd you pay for it? With my wages. So it's community property. Wait a minute, they were my wages. Well, you didn't come into the marriage with them. You didn't inherit them. So they're community property, and anything you buy with community property is community property. Now, why do we care? There are two contexts in which this becomes important, and the treatment is not the same. The first is a terribly sad situation. The couple has decided to go their separate ways. As part of the dissolution, the assets are divided. How's that done? Husband gets his separate property, wife gets her separate property, and the community property is divided 50-50 as much as possible. There's usually some horse trading on this because, well, if there's a house, you're not going to take a chainsaw to a house. And if you are, you have bigger problems than just the dissolution. But at least the mindset in that context is community property is a 50-50 proposition. The other context has very different treatment, and that's in dealing with third-party creditors. So let's say you have a debt to ABC Bank. Your spouse knows nothing about it. You're not paying. What can ABC Bank do? Well, I think we can all agree ABC Bank can go after your separate property because, after all, it's your debt. You signed off on it. And if you were going your separate ways, you take that with you along with the debt. I think we can agree, fair is fair, that your spouse has separate property, and that separate property is not liable for the debt. Because, after all, your spouse didn't sign off on this debt. What about the community property? Can the creditor go after that? Absolutely. 50%? No. 100%. Now, you might wonder why the difference there. Why isn't it a 50-50 proposition vis-a-vis third-party creditors? Well, the law has determined that it's an undue burden on the creditor to try and figure out which half is yours and which half is your spouse's. The way that's resolved is the creditor gets to go after all of the community property. What does this have to do with filing a bankruptcy? Well, if you file together, then there really isn't this complication. You're just listing all of your assets separate in community, listing all of your income, expenses, debts, and so forth. But let's say you file by yourself, and you're certainly permitted to file by yourself. What do you have to include in your petition? Well, I think it's without controversy. You'd have to list your separate property. You'd have to list your wages. You'd have to list your debts. You'd have to list your expenses. But you also have to list your non-filing spouse's assets except for separate property, because your spouse's community property is liable for your debts. You have to list your spouse's debts. My spouse isn't filing. Why? Because your community property is liable for your spouse's debts. So you list your spouse's community property assets, your spouse's income, which is community property. You list your spouse's debts. You list your spouse's expense. And so, for all intents and purposes, there's only one thing that's being excluded, and that's your spouse's separate property. So you might wonder, well, why bother to make this distinction? Why should I file by myself and not have a joint case? I've had this come up in 3 different forms in various cases I've had over the years. The first, The couple just got married a couple weeks ago. One of the members of the couple has a bunch of debt, the other has no debt. Well, it makes no sense to do a joint case, even though, yes, California law does say that the non-debtor spouse inherits liability. But if you just go through that bankruptcy by yourself, there aren't any documents that will tie your creditors to your new spouse. So in that situation, it makes perfect sense to file as an individual. Second context, a few years ago, your spouse did a bankruptcy. And let's just say we're going from Chapter 7 to Chapter 7. That's an 8-year window that you have to wait from filing date to filing date. Your spouse is ineligible to get a Chapter 7 discharge. So there's no point in the spouse filing because the spouse can't get a discharge. So you'd file by yourself. Third situation, maybe the non-filing spouse simply does not want to file for bankruptcy. It's not like we can just take a gun and order that spouse to file. So in that situation, it makes perfect sense to file as an individual. Now, unlike Chapter 13, which has something called the co-debtor stay, which supplements the automatic stay and not only stops creditors from coming after the debtor, it stops creditors from going after co-debtors. Chapter 7 doesn't have such a thing. So if you were to file an individual Chapter 7, your non-filing spouse could be liable on any of those debts. The creditors can still go after your non-filing spouse while your case is pending. But once you get the discharge, then this automatic stay that has been protecting you terminates, and it's replaced with something called the permanent discharge injunction. And what that says is creditors are forever stopped from going after you to collect any of the discharged debts or going after any community property. So the only thing that could be at all liable in this situation is your non-filing spouse's separate property. And if you've been married for a long time, chances are there is no separate property because over the years you've tossed broken things out and bought new things with community property. So this may be a non-issue and your non-filing spouse may not have any concerns at all with being harassed by creditors because of that very expansive discharge. Now, not all creditors are aware of what is covered by the discharge injunction. So there is the nuisance factor that if a creditor contacts your non-filing spouse and says, you didn't file for bankruptcy protection, you owe us, then you have to write a letter and say, well, look, this provision in the discharge injunction, if you're at all curious, it's Section 524A3, says that you can't come after the non-filing spouse's community property. This non-filing spouse has no separate property, so leave. Because the creditor might in innocency be trying to collect from the non-filing spouse. So that does create a bit of a nuisance, and if you file together, the nuisance factor is gone. But strategically speaking, it may make sense to file by yourself, because if you go through the bankruptcy, and if God forbid some couple of years down the line, you as a couple fall into some more financial hardship, the other spouse that didn't file is not stopped from filing another Chapter 7. It just won't include you. So this is a somewhat complicated question to answer if you have the whole picture, but the simple answer is no. You do not have to have your spouse file with you.